Yes. What about Mosika? Want to make a mention?
My lord, on to some competition, my lord.
Which one?
This, with Mr. Dasgupta, my lord. This is 36.
36.
It will not matter.
Yes,
Just 1 or 2 days, my lord.
You want the money? Is ready to give him.
My lord.
Not ready. You said he'll get it ready by next date.
Yes, my lord. It is all. I am the worst sufferer from
Pass an
2017.
order, my lord. This department is not agreeing.
Then
We will have it then next week, yes. Yes.
day after tomorrow.
Now tomorrow what day? Wednesday?
12.
Depends on.
Yes.
Yes. Thursday, my lord.
Yes.
Much obliged. Your Honor, Lordship, I have already dealt with those cases where there was a damage to structure on the acquired land and assessment certificates were issued. I have also taken to this Honorable Court to the evidence available and to
CW?
the
No, you only CW 73, 73 on structure, CW 74, 74 on DF4. The next CW is what? On horticulture? You finish CW 73,
Yes.
72 on structures. Then
Yes.
74 and 75 you said on horticulture.
And
Now you've
horticulture
done
and the
74,
forest product.
75 you have not, 75 is whom?
Forest product and the horticultures. These are the two
75.
items. With regard to your Lordship, forest product, we have examined PW 74 at page 22,
That is additional paper book.
additional paper book. Forest product, your Lordship, was only in respect of one claimant, that is petitioner number 1. He has filed a separate appeal, that Armstrong same. He is not included in the cross objector. He says that I am a qualified divisional forest officer of the Khasi Hill Division, Shillong, and I am convergent with the procedure of making the assessment of the forest product. I have made physical verification of the land of petitioner serial number 1, namely Shri so-and-so, which was proposed to be acquired by the opposite party for National Highway Shillong bypass at village so-and-so. On my physical verification, I found that there were 160 number of the Tita Champa tree, A1 Diang Rai trees standing on the land. I have made the assessment of the said tree as per schedule of rates of royalty on forest produce, Government of Meghalaya, effective from 12th November 1998, Department of Forest and Environment, Meghalaya, and issued the assessment certificate in respect of the same to the above petitioner. The Exhibit P12 is the said certificate of assessment, and Exhibit P121 by...
How much was the assess?
Lordship, come to page 75, that is the assessment. He has assessed at 8,96,000.
How many trees?
160 at the rate of 5600 per tree.
These are very precious trees.
Sir. And he proved this certificate. Then your Lordship, for hybrid, we have examined PW 75.
Yes.
And your Lordship, in the cross 24, Lordship will find that there is nothing substantial, save and except to say that I don't agree that in the year 2007 there were no trees standing in the land of so and so. as construction.
Which page reading?
Page 24. The cross of PW 74.
Okay. Okay.
P1 थोड़ा बाद में दिखाता हूँ इसको. Then PW 75, he has made the assessment of the horticulture plantations in respect of these claimants.
How many days are there?
These are, Your Lordship, 1, 4, 5, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10,
Only
11.
banana trees only.
Yes, 50, 55, 56, 50,
Okay.
18. 18, apart from the individual appeal. In individual appeal also same thing is claimed. They are also included here. He says that during 2007 I was posted as District Horticultural Officer, Ribhai District, Nongpo, and during my tenure as District Horticulture Officer, Nongpo, I have made physical verification of the land of the petitioner number so and so, and in the instant LA case, and on verification I have counted the plantation.
Only
of
banana
fruit.
trees.
Sir?
Only banana trees.
No, there were other plantation also. I have counted the plantation of fruit, etc., standing on the lands of the said petitioner, made assessment and issued the assessment certificate of the said petitioner. The assessment was made in the boundaries of the land proposed to be acquired by the opposite party for the purpose of National Highway Shillong bypass. Then, Your Lordship, he exhibits the assessment certificates and proves the same. Then, Your Lordship, come to page 30. The only question which is put there, that I agree to the suggestion on that the banana plant is the only fruit bearing plant that bears fruit only once in its lifetime. Your Lordship, I just take to now assessment certificate P1 79. Page 79 is the Tita Champa. Page 75, Your Lordship.
That you've seen.
Page 75. This is with regard to Tita Champa forest product. 75. Similar type of certificates. Now, there is only one claimant where this forest product is involved. He gives this.
So
Then
and in 74 bananas.
no, I'm coming to banana. Banana is 74. Yes.
For that.
Bananas, Your Lordship, is at page 74.
Of Armstrong's aim.
A lifespan of the plant 6 years, one bunch of banana valued at rupees per annum, fruit production period 4 years, 840 number of plantation, and total comes 13,44,000, Your Lordship. Now, what is the finding of the trial court? I just take to Your Lordship. Page 139 of volume 1. For compensation for damage to hybrid tissue cultured plantation of which he deposed in his evidence to have 840 number by relying on the certificate issued by District Horticulture Officer, Ribhai District, Nongpo, proved under his signature at Exhibit P1, and also relied for support on evidence of common witness number 75, Shri Evangel Shampru, retired District Horticulture Officer, who deposed that he has made physical...
Okay, you 50% on both.
Sir?
50% on both.
50% on both.
All right.
Now, the reasoning which is given for for the C is dealing with the paragraph C is dealing with the Tita Champa. Claimant deposed to have 160 number of his. Apart from this expert witness, even the claimants have stated in their evidence also is required to be considered, Your Lordship, which the reference court has not considered. They have also given the evidence. With regard to the rates and forest product as well as the horticultural plantations, then what is the decision, Your Lordship, on issue at B and C, that is Tita Champa and hybrid? On issue at B and C above, since the claimant has been able to prove the damage of hybrid tissue culture plantation of 840 number and damage of Tita Champa trees of 160 number, which the OP collector had not adduced evidence otherwise, nor could OP collector topple the evidence of claimant's common witness number 74 and a common witness number 74 district forest officers, East Khasi Hill Division, Shillong, respectively, who are also found qualified person in their respective field, related for assessment of such plantation which remain unrebutted. Hence, this court is inclined to believe the claimant damage of number of such trees at above issue B and C of the claimant number 1. However, this court is of the opinion that though it would be fair to assess the potential earning of the said plantation if not felled for acquisition, but since the assessment of PW 75 and 74 respectively was not explained if assessed on the lifespan or the size of each and every tree, nor about the expected earning from their produce of each and every tree, but the document at Exhibit P1 issues to the generalize every tree at same size, same lifespan and same produce, hence keeping in mind the assessment of PW 74, PW 75 being by numbers of tree only as a lump sum assessment. Hence, this court will accordingly take the average lump sum rate calculation of 50% as above for the calculation from their claimed tree for compensation of their plantation. So, reasoning what is given, Your Lordship, that assessment is not explained here. He was an expert witness, Your Lordship. And that it is assessed properly.
What say, sir, my experience just says that you have not shown, you have generalized assessment.
Yes.
Assessment has been done at that much, one per tree is, for bananas also, for tree also has been assessed. But he said it's generalized. They've not given specifically which trees. So that is he's saying, see, average girth, 96 centimeters, valued at rupees 5,600 per tree. That's what, 160 number of trees.
Yes.
That's a generalized assessment.
Yes, Your Lordship. And since he said in his evidence that I am quite content with the system of assessing this damage, and he has assessed and issued the certificate, and the state has not challenged it. And in view thereof, Your Lordship, the court was not justified to give 50%. And 50%, whatever is cut, I would humbly submit that, Your Lordship, that should be given back to the claimant, and that is the aspects by which Your Lordship can compensate the claimant's landowners, Your Lordship. And cost. Your Lordship will give me 1 minute time. Your Lordship will just take 27, section 27 of the LA Act. Your Lordship, this section talks about the cost.
What cost?
Cost. Section 27. Every such award shall also state the amount of...
Different argument.
Sir?
Different limb argument.
A different limb of the arbor, but this is what was required to be provided and which is not provided. And this honorable court, while looking at the miseries of the landowners from the last 22 years, will possibly think it appropriate to look into this provision and award adequate cost to the landowners for the last 22 years of litigation, Your Lordship. And which will...
No cost awarded by the reference court.
No cost was awarded by the reference court, Your Lordship. Now, Your Lordship, whether Your Lordship, I have successfully proved the market rate or I could not prove successfully, that for this honorable court to come to the conclusion, Your Lordship. And Your Lordship will consider at least the equitable relief which could be granted to the landowners and this court judgments, most of the judgment which I have gone through reflects the equitable relief, even if the claimant was not found to be. What Your Honor thinks, Lordship thinks, that...
Not what the Lordship thinks, is what the law, in accordance with law, we say.
No, according to law, and according to law, naturally, Your Lordship,
Yes.
according to law,
Yes.
and according to law, the sale deeds are there. Sale deeds are there. Now, maybe the price reflected in the sale deed, Your Lordship can, by the experience of this court, may say that this is on the higher side, and we will consider only 50% of this rate which have been reflected in the sale deed, Your Lordship, or whatever, Your Lordship. And so far the interest portion is concerned, Your Lordship, the interest is awarded under section 34 only, 34. And interest under 23(1)(a) is not awarded, which is mandatory. And at least this 50% cut is restored to the claimant. And the cost is awarded for 22.
Cut of the trees and for the bananas.
Yes, Lordship. And if the cost is added, that possibly will be a very equitable proposition, which I humbly pray Your Lordship to consider it. Instead of sending it back to the court, nothing will happen, Your Lordship. After 22 years, Your Lordship, I don't think any evidence are further available with us, to make a case. That is my, Your Lordship, humble prayer to this court.
Lordship, I have a lot of ground to cover. Kindly allot me any one day.
No, we'll take
Preferably
no problem.
Friday. Friday or next Monday.
Monday is a holiday.
Tuesday then, 18th.
18 and
Election petition.
18 waiting evidence.
So any other day which is convenient to my lord.
We shall give a date.
Lordship.
Yes,
The check of the date.
We'll say, oh, you can't be appellant also, you're appellant and cross-objector also. The which Benjal has concluded his arguments. This for replies and so on. So.
Only, Your Lordship, those 6 independent appeals, वो कहाँ है या कौन सा अपील में क्या क्लेम किया है? There are, Your Lordship, 6
Because only
appeals.
one thing, Mr. Jindal, you have given judgments on maintenance plea.
Yes,
That is
sir.
not, have you given them?
I have given. I have given. Number 1 and 2 are on the maintainability.
The judgments?
And if Your Lordship hold that appeals are not. Only one thing, Your Lordship, I'll.
Not maintainable, then they end there, here, they end there, and then there's no question of going into merits appeal.
No, then independent appeals remain. Independent appeals remain. Lordship, that 6 independent appeal, for what purpose it is filed, I'll just give a note on that.
You have to let the arguments get concluded, then I'll ask whatever necessary.
Yes,
Court
Lord.
will inform. Because we'll need some written argument, not written arguments, at least a collation of all the yes. If I had known it's only for 15 or half an hour, we could have continued from the first half itself. I thought that you need another 2 hours. That's why I said, okay, 2:15. I thought we'll conclude by 4:15. But it seems it's